The 7 Deadly Mistakes That Inventors Make by Shine Enterprise.
Welcome to your next deadly mistake, trying to license your invention prematurely. In this deadly mistake, you're going to see the thought error that occurs in so many inventors who are trying to license their invention. If that's you right now and your hope is to get a company to come in and actually bring this product to market for you, maybe take care of a lot of costs, maybe take care of a lot of patenting, and ultimately pay you a royalty for this product selling or going to market, this is very, very important to you. This is a thought error I've seen with a huge amount of inventors who want to license their product or license their invention. You're going to see the thought error that occurs, and you're also going to see the solution. And I'm also going to tell you some of the reasons why licensing your invention in some cases is a lot more challenging than you might realize. So let's take a look firstly at the real error that occurs. And this, thinking about this, of course, as you imagine, over the last few years, I've come into contact with a lot of inventors. About 80% of my clients are from the US, where licensing tends to be the go-to kind of procedure. I personally want to bring quite a lot of my inventions to market myself, but in the US, it seems that about 70 to 80% of inventors want to license their invention. And as you can imagine, I've come into contact with a lot of inventors, and one particular person is coming to mind here, which was a very nice lady who had an invention. I couldn't tell for sure whether it was viable because it wasn't necessarily my area of expertise. But I do remember this. She sent me a message saying, and I think I'm right here, she said, I've emailed the details of my invention out to 3,000 companies and I still haven't got a licensing deal. 3,000 companies. So she had literally sent this out to thousands of companies trying to get a licensing deal. And this is one of the positions us inventors, in the past at least, before the inventor's journey, found ourselves in, and maybe you find yourself in, where you feel a little bit powerless. You don't really know how to contact and engage these companies. And so you just do this kind of, you get this mentality, hey, if I just send this out to as many people as I can, maybe something will stick. That can be a real problem. This person had a video of their invention. They didn't, and this is a key thing, they didn't have any physical builds. They never built their invention at all, which, as you know, is very against my methodology when it comes to moving forward with your invention. But she did have an animated video, which had been made quite painstakingly with people moving around and using this version of her invention, which was kind of rendered into this video. I've got to say that the version of the invention looked a bit unrealistic. It didn't, from a product designer point of view, looking at it, I was not too impressed with the quality of what I was looking at. But it showed the general idea, and she had then sent this email, maybe with a link to this video or a compressed version of this video, to 3,000 companies and nothing. So what was going on here? What was going on here, if we look at the inventor's journey, is that this lady, lovely as she was, and I remember how positive she was as well, she had missed out absolutely key steps in the inventor's journey, which had left her relatively powerless. All she had was effectively an idea, which she had made into a video at fairly low cost. She'd done well to get the cost, that it was made at, but it was still really just an idea, and she was sending this out. This is the first lesson you've got to learn if you're trying to license your invention. If you don't have a physical build of your invention, you might as well go home right now, because you're actually living in the world of imagination, not in the world of reality. When I started out, I can remember when I first got the first ever renders of DishShine. I may or may not put those on the screen right now because they're totally different from how DishShine actually turned out. I remember being quite excited, and I look back and think I was not, maybe I was a little bit naive here, but because they were quite jazzy looking, I thought this was a big step forward. But you know what? It wasn't. These are just graphics on a piece of paper. Just as this lady had a video, it's just video. It's not a real thing. You've got to take your idea into the physical world. And if you think that you're going to get a licensing deal, you're going to license your invention just from graphics or from a video, an animated video, or from explaining your invention to someone, you might as well go home right now. And one of the main problems in this industry, and the reason why this type of stuff has been going on, is there are companies, most notoriously companies like Davison, and also I believe InventHelp sometimes do this as well, although I don't know their model very well, so I can't confirm that. In certain cases, Davison, I know for a fact, do graphics of a concept and then send that out to companies. Now, my experience living in the real world as I do and knowing this industry is that sending graphics out to a company, especially some very poor quality graphics, and I have seen what could be described as extremely mediocre graphics. I'm probably being nice there, from Davison. I saw something which they charged $7,000 for, which I probably could have got for about $120 to $200 online. You've got basically zero chance. And the model from Davison shows that they have a very close to zero, literally very, very close to 0% success rate. InventHelp, as far as I know, sometimes help with this as well, creating animated videos. I don't know what the quality is because I've never seen them, but I've seen them talk about this on their website. Again, I would expect the success rate to be almost a big fat zero on those types of things, even if you've got quite a nice animated video. Even if you had a world-class animated video, and I've done that, I've done one incredible video for someone who used to work for NASA and had an amazing invention, I would still think that whilst that's a good presentation tool to a certain extent, that is still about a 0% chance. Anyway, so that's why we do a proof of principle in the inventor's journey. You need to one thing to take from that is turn your idea into reality, bring it into the real world. This is going to hugely enhance your chances of getting your invention to market. When you do the proof of principle, it's going to teach you about your invention, help you with knowing how to patent it, knowing how to move forward with build it, etc. But the key thing here is the prototype step. Now, between the proof of principle and the prototype, we've of course got product design, and then we move on to prototype. The prototype is the absolute key because the prototype is where you're going to try to make as close as possible to the final version of your product, as if it would appear on the shop shelves, or with, for example, with the knee surgeon I'm working with right now, as if it would look in the surgeon's hand. Again, I might be able to show a picture of that on screen right now. We're trying to do a finished version of your invention pretty much, but without all the batch and manufacturing and tooling costs, which could cost hundreds of thousands of dollars, that the final, that tooling your own invention would cost. And this is a key thing to bear in mind before I move on. Even when you have your final prototype done, which would be a really powerful tool to you licensing your invention, because you can then show that prototype and do, more importantly, a trailer video of that prototype, a professional video of it, and send that out to the licensing companies, which is much more impressive. There are certain things you have to be aware of when you're trying to license your invention. These are significant reasons why people might not want to enter into a licensing deal with you. The first one is that manufacturing and tooling of your invention could cost a huge amount more than you realize. It is not uncommon, even with basic inventive products, for tooling of your invention, in other words, making the factory tools that are going to be used to create, these 10,000 units of your invention, it's not uncommon for them to cost around $70,000 or more. So just bear in mind that even for a very basic invention, it could cost tens of thousands of dollars to manufacture and tool up this product. So you can understand straight away that when you're going to these licensing companies, from your point of view, if you're a first-time inventor, and I mean this respectfully, slightly naive about the process, you're thinking from your point of view and thinking, oh, if they think it's a great invention, they're going to enter into an agreement with me. Well, no, they've got other considerations as well, like the fact that this could cost them it could even cost $250,000 for them to tool and manufacture the first batch of your invention. It's not uncommon for it to cost $250,000. So they've got a lot of things to bear in mind which are going to count against you. They might think, it's a great invention, we just can't take that risk right now. So that's one thing you've got to factor in. A second reason that you might want to factor in, and this is why you'd imagine big companies, for instance, Dyson in the, floor cleaning apparatus or kind of vacuum cleaner industry. Companies like Dyson, I wouldn't be surprised if they refused to even talk to inventors about licensing. You might think, why don't they do that? I mean, there could be great ideas out there. Well, let me tell you as a patent specialist why they might not want to do that. If they enter into a talk with you, or let's say Tom Shorthighs with his upward cleaning apparatus, this new idea for cleaning upwardly and outwardly with this fan-shaped brush in the future. Let's say a version of that was made which looked great and looked great in the shops, was very extravagant looking, and people wanted to buy it. Well, before that even happened, let's say Tom wanted to speak to Dyson. Well, especially if Tom hadn't published this or if it hadn't been patented yet, this would represent a very serious risk to Dyson. Because if they entered into talks with Tom, let's say that Dyson in the background had actually thought about this concept even before they entered into an agreement with Tom. Or when they when they start talking to Tom, they might have to sign an agreement to say that they're not going to move forward with Tom's inventive concept, that it's confidential and that they won't move forward with this. Well, what if they'd already been working on something, maybe put something on the back burner to do with this concept, and then when they talk to Tom, they sign this agreement? That might effectively put Dyson in a very difficult situation where if they take this concept, which they already come up with, off the back burner and start trying to move forward with it, Tom will think that they've stolen his invention. They're then going to have to prove maybe in court that they came up with it first. So it can bring in all of these, problems. Maybe Tom, if Dyson speak to Tom, maybe Tom will disclose to them. Maybe from Dyson's point of view, maybe they would have thought of that idea themselves within the next 1 or 2 years anyway. And by speaking to Tom, they're now limited to the agreement with Tom and having to pay him money. A lot of other things could come into being. What if he doesn't patent it perfectly, but they enter into an agreement with him? Other competing companies move forward with it as well and don't have to pay Tom, whereas they do have to pay him a royalty. A lot of problems, legal problems, can start to happen. And this is why a lot of big companies just won't even speak to individual inventors like you. So you have to realize that you're up against it. Now, how can you solve this problem? I've talked about the problem. Let me solve this and talk about the solution for you. The first big solution to optimizing your chances is definitely to get a prototype done. You have to go through the inventor's journey. You have to get out of the habit of thinking that because your invention is so good, some company are going to come in and magically take it to market for you and pay all the development costs and pay all the patenting costs. In truth, and again, I mean this respectfully because I've been there before at the beginning of my career. In truth, is that not actually just lazy fantasy thinking from you? Think about it. Is that not actually just you fantasy thinking so you can not think about the problems and the reality which might occur in bringing your invention to market? It would all be very nice, wouldn't it, if you disclose your invention to some company and they said, you know what, this is amazing. We're going to take this forward ourselves. We're going to pay $250,000 in manufacturing and tooling. And by the way, I didn't talk about marketing as well. They might have to pay another, $100,000 in marketing for this product moving it forward. They might have to change their marketing strategy. Another reason why licensing companies, apart from the cost of it, apart from the cost of tooling manufacturing, apart from the cost of marketing, they might have to change their whole product strategy because your product might effectively cannibalize some of their products. What that means, you might have heard that term if you've read the Steve Jobs biography by Walter Isaacson, you'll hear this term. Apple sometimes have to release a product which cannibalizes one of their previous products. What that means is that it cannibalizes the sales. So they might have a product which was doing well, which was released 4 or 5 years ago. They then have a new product which is much better and does different stuff, but also might eat into the sales of that old product because it does things better. That's called cannibalization. Now, Steve Jobs mentions this in his book, and he was asked, someone said, well, should we release this new product if it's going to cannibalize, our old Apple computer or whatever it was? And Steve Jobs said, well, I would rather one of Apple's own products, one of our products, cannibalize one of our own products than some other company come in with a new product and cannibalize ours, right? So your new product might be so good that it might be a step over their own products and it might pose a risk to the sales of their own products, right? So they might say no to you because they're scared of your product. So you can imagine, not only are there these problems which can get in the way even if your invention is great, but your invention could be so good that they might not want to enter into a deal with you because they're scared of your invention. So as you can see, licensing your invention is more difficult, more challenging than you can imagine because there's several reasons why this might not happen. This is why it's such a big problem in this industry, why companies like Davison and InventHelp allow inventors to think that this is a route forward for them and that they allow inventors to stay in quite an uneducated and unknowledgeable state of why this might be so challenging. So, going back to the solution, the first solution is to get a prototype. Forget thinking some company, some licensing company is going to come in and do all this stuff for you and develop it. You're going to show them a graphic or a basic version. They're going to pay all the development costs at $60,000. They're going to pay all the manufacturing tooling costs at $100,000. They're going to market themselves at $100,000. They're going to pay their own staff for all these talks that they have to have about this product for another 60 grand. They're going to pay all patenting costs worldwide for, let's say, because a patent attorney might charge them $50,000 for this. So they'll pay all that as well. Get out of that mind frame and realize you're going to have to do this by yourself. The Inventor's Journey is here to help you do that. The first key step is to get all the way through the Inventor's Journey. Remember, you have to fulfill all these steps and get to prototype. So you need to get a final version as if it's ready on the shop shelf because this will mean you've done a lot of the work for these companies for you. There's a couple of other things to bear in mind. The first thing, when you get the prototype, you're then going to get a trailer video. The trailer video is the gateway step that is going to allow you to, one, license, but also license or crowdfund your invention. So what I want you to do if you were trying to license your idea is actually think about this. You might license your idea, but you might also have a chance to kickstart this, maybe Kickstarter or Indiegogo. You might be able to do this by yourself. And the bottom line is, if you can't get a licensing deal, that's going to be the only option available to you. Open your horizons. There's a lot of stuff I'm going to be putting into effect at the trailer video step and also at the crowdfunding step, where I'm doing something called the crowdfunding package, where we're going to work out all the costs you're going to have to make as part of your target. So bear in mind, you might be able to do that. But the key is that you've got to get the prototype and you've got to get that trailer video ready. So I hope you learned a lot from this deadly mistake. Let's take a look at the summary.
If your intent is to license your invention, the single most important step for you in the inventor's journey is the prototype step. If you haven't physically built your invention and got it to the final product level, then with the greatest respect, you can pretty much forget about being able to license your invention. And having even a decent demo version just isn't enough. You need a finished final prototype that looks and functions exactly as if it were being sold on the shop shelf right now, as if how it would work in the hands of a user. In other words, it needs to be sales worthy before you even present to these companies you want to license to. This will help you because it will, one, show the companies you want to license to that you're truly committed to your invention. Two, it will mean that you've done a lot of their work for them and that they're entering into an agreement with you at a time when the product is already fully developed. And three, it will give them the vision of your final product, rather than you hoping that they'll just get your invention and convert it into a product themselves. This way, the final product is there right in front of them, ready to sell. That makes it more likely they'll want to go ahead because the road is so much clearer and simpler for them. Think about it from their point of view. Don't fall into the trap of thinking that because you're trying to license your invention, you can skip all these steps that inventors have to do if they're trying to get their invention to market themselves. In other words, don't think that licensing is some sort of shortcut compared to getting your invention to market yourself. This false thinking has not been helped by companies like Davison and to a lesser extent InventHelp, who have ultra basic 2 to 3 step models that culminate in you trying to license your invention. These models have been proved to have almost no success at all, and they keep inventors in a state of ignorance, thinking that licensing could be the shortcut compared to doing everything yourself. But here's your key mind frame change, which is also going to give you 2 chances of success rather than just 1. If you want to license your invention, forget thinking about it as a shortcut and forget the idea that some company is going to come in and do all of this for you. Instead, and this is the key mind frame change, act exactly as if you were trying to get your invention to market yourself. Go through each step of the inventor's journey in sequence, just the same as an inventor trying to bring it to market themselves. As you complete each step, your power will increase. Don't do what that nice lady did and just do a few steps, miss quite a few out, and then try to go straight to contacting 3,000 companies in her case, just off the back of some graphics, a video, or an email showing your invention. Instead, complete every step. What you'll find is that if you do that and get to the prototype step, things will start to get exciting because you've now got far more power on your side and you've got the final product in your hand, your final product ready to sell in your hand. You're in a much better position, a much more professional position at this point to license your invention. What you'll do next will sound counterintuitive. Of course, you'll trailer video your invention because that 60 to 90-second video is the most powerful and important presentation tool in the world. But then what you're going to do, and this will seem counterintuitive, is crowdfund your invention. Yes, you'll try to license it, of course, but you'll also try to crowdfund it. In other words, you're going to have 2 goes at getting your invention to market. And the reasons for this are several. The first is interesting. I've already seen one product created by someone I know go on Kickstarter, which failed completely to get funded. It wasn't even close. But what happened next? the person who created that product got an email. It was from a company that had seen his Kickstarter campaign and his trailer video, which he uploaded to YouTube, a very, very basic video. And they wanted to manufacture and move forward with his product. They spoke closer, had more detailed discussions, and then this company offered him a very significant percentage for him to license the product to them and for them to move forward with manufacturing and selling it. He agreed, and now they're moving forward. In other words, his Kickstarter, his crowdfunding campaign, which failed miserably, was directly responsible for him licensing his product. And it gets even better, because if your crowdfunding campaign is successful, gets successfully funded, not only will you get your invention to market, but if you have a reward as part of your crowdfunding campaign that includes your funders, the people who back you, getting one of your products when it's successfully funded, in other words, when your campaign gets successfully funded, they get a unit of your product sent to them, and you should always do this as part of your rewards. If that happens, you can actually make your first sales of your product through Kickstarter or through Indiegogo. This then has a ripple effect, because if you sold your first 1,000 units to your backers on Kickstarter, not only is that going to make companies more interested in entering into a deal with you for you to license your product to them, but it will mean you have a stronger position at that point to negotiate a larger percentage in that deal. In other words, you can leverage you getting a better deal when you license your product to them. After all, at that point, you're not just a person with an idea like that lady who just had a video, didn't have a real product, just a video and sent it out to 3,000 companies. You're not like her at that point. You, at this point now, if you got successfully funded, you now have an invention that's already selling. That's much more attractive and gives you more power in terms of negotiation. And also, going public on YouTube with your trailer video, where you could get hundreds of thousands of views, drive those people towards your Kickstarter campaign, and possibly get hundreds of thousands or even millions of views, that could have another beneficial effect on trying to license your invention. And that's that it negates the legal worries that some companies might have in signing confidentiality agreements with you, these agreements which could potentially tie them up. And this is one reason why a lot of these big companies don't actually allow individual inventors to disclose them. They won't need to sign a confidentiality agreement with you now, because after all, your invention concept is on YouTube. If they can see that, suddenly you're much less of a legal risk to them. So it negates that problem. If that does happen and you're disclosing going public on YouTube, Kickstarter, and these companies, just make sure you've got great patent pending status and ideally have already filed your non-provisional patent application by the time you crowdfund. So that's the big mind frame shift. Act as if you were trying to bring your invention to market yourself, even if you're going to try to license it. Complete every step in sequence of the inventor's journey and watch as your power and influence over this situation grows.